Recording in progress.
Ma'am, we will start the session shortly. Michael Jordan once said, "Get the fundamentals down, and the level of everything you will do will rise." With this inspiring quote, greetings, fellow inquisitives of the legal sphere. I, Niharika Singh Rajawat, on behalf of Kanodia School of Law for Women, Jaipur, Rajasthan, is delighted to invite you all on the first day of KSLW third Moot Court Training Workshop. As we dwell into the fascinating realms of fundamentals of muting, in today's session we will equip you with the tools knowledge to excel in the fundamentals of the muting. Today we have with us Ms. Ramya Prakash. Welcome to the session, ma'am. Ma'am is a dedicated legal profession with a master's degree in law, specializing in corporate and finance services from the prestigious National University of Singapore. Currently, ma'am is serving as an assistant professor at the School of Law, MS Ramya University of Applied Science, Bangalore. Ma'am brings a rich blend of industry and academic experience to her role. Throughout her career, Ma'am has been affiliated with various law and business schools, teaching subjects such as competition law, corporate law, international law, legal and business environment, and contemporary legal Indian society. Ma'am's expertise extends beyond academia into consistency, where Ma'am has advised companies on regulatory compliance, legal agreements, and due diligence matters. Passionate about community service, Ma'am actively volunteers with NGOs supporting children and the elderly. Ma'am is also seasoned speaker, having delivered guest lectures and conducted workshops at numerous organizations and colleges, where she shares her extensive knowledge and practical insights. Ma'am's multifaceted career reflects a commitment to both legal education and societal contribution, making her an invaluable asset to the academic and legal communities. Thank you, ma'am, for being with us. Before beginning the session, there are some guidelines for the participants. Firstly, all the participants are required to keep their cameras off and audios on mute. Secondly, at the end of the session, a feedback form will be dropped in the chat box, which will be filled in order to receive the participation certificate. Kindly note that the certificate will be provided via Google Drive link in the WhatsApp group within 7 days. Kindly do not leave the group immediately after the session. Thirdly, in case of any misconduct, the participant can be disqualified from the workshop. Thank you. Now request Ms. Ramya Prakash ma'am to commence the session. Over to you, ma'am.
Thank you very much. This was such a warm introduction that you gave, Niharika. So really appreciate that. Good morning, everyone, or good afternoon, almost. It's been a great pleasure for me as we are here today to discuss, or rather, build this very foundation of mooting. So here, when I say mooting, this is nothing but not it's not a curricular or a co-curricular activity. It's more like a heartbeat for a law student. This is where where knowledge and practice meets together, and this becomes the most essential requirement or a skill for a law student, because this is where you try to understand what advocacy is, and how your courtroom skills get enhanced, and how your critical thinking sharpens, and you learn the art of researching and also enhancing your public speaking skills. That is why we thought, or rather, I've simplified in our discussion, or trying to here help you navigate or understand the basic things, or what helps you ace not just moot courts, but also to be a great lawyer. Let's now, in this session, what I would try to help you is what are the components of the moot, what is a moot, and help you understand or try to differentiate what a moot is and what a debate is, and how moot court is going to be different from a real court, or are there any similarities, and then help you try to make you understand what the facts are, what are the issues, and how do you master your writing and your oral presentation. So thank you very much for joining me, or rather giving me an opportunity to be part of your Moot Court workshop. So without much you know any more delay, let's begin or try to start our session. So now when we are saying moot, so first we have to understand what is a moot and how different it is going to be from the real court. So what is the importance of mooting in a lawyer's journey? So when we are saying a lawyer, so here always remember, a lawyer's work begins with one, you need to be patiently hearing what your client says. So after which that becomes your the most important skill. So you hear, and thereafter you advocate, or your advocacy skills comes into picture. Now the next question is, there could be a few of you here who says, I don't want to be a litigator, but I want to be a non-litigator. So that is where you have to understand, where it's not just about speaking. Here you try to understand how the legal system works, because moot court simulates a real court situation, and there you try to understand your legal how the procedures are. It'll enhance your case analysis and also your research skills. So this is where I say about hands-on research. Why hands-on research? Because you try to put, maybe in classrooms we learn what the law is, but there is never an application aspect of it. So here in moot courts, it gives you an opportunity to make use of that research, where you apply it, where you try to understand what are the different treaties, what is the precedent, what are the case laws. So that is a very, very important factor, where you try to, understand one, whatever knowledge you have gained in classroom, you put into practice. So this is how important mooting is for a law student or for a budding lawyer. Now, the next question here that I would want to address here would be how a moot court is different from a real court. So, for instance, I've here given an example of a trademark infringement case. So, in an actual courtroom trial or in a trial, what becomes easy, it could be in a criminal case, or it could be instances like these IPR infringements, where if the evidence is clearly on one side, or if here it is showing there is a defendant's violation, it becomes very easy for the plaintiff lawyer to prove, or it's ensuring that it's one-sided and there's a real win. While in a moot court, what really happens is you have to ensure that the both sides have been fairly represented, and if in your memorial, for instance, it is favoring, or rather it is where your arguments are stronger on one side, then the competition as such becomes less challenging. So that is why generally a moot court or a moot problem would ensure this component, where you are able to argue for both the sides. So this is the fundamental difference between how a real case and how a moot problem could be slightly different. So I've just given you here just a tidbit humor, where you cannot say, can I use, or can I argue a different story, because you cannot change the facts of a particular case. So now comes to help you understand what mooting becomes, or what is a moot. So mooting is a simulated court setting, where you try to argue a fictional case before a panel of judges. So when we say it's a simulated court proceedings, that means you are going to uh, uh, include, or rather, what are the skills that is required for you know you participating in a moot court competition is: one, you should know how to research. Second is how well you draft your memorials. So third is going to be your public speaking skills. That is how well you argue or advocate for your client before the panel of judges. While you're doing all of these, that is when your soft skills, that is, you confidently argue before the panel of judges, you learn to communicate better. And since a moot is usually a team representation, you learn to, work better as a team. That is, it could be, the two speakers, including a researcher. So it's going to be a team effort. And that is when you will learn all of these: how to research, how to speak, and how confidently you're going to put forth your point. So when I'm saying mooting, so is what since you're all attending a workshop, so these are some prestigious moots that all of you should be considering in taking part. So one is the Philip Jessup International Law Moot Court Competition. Then is Prize Media Law Moot Court Competition. Then there is Nelson Mandela World Human Rights, competition. So these are the most prestigious moot court competitions where students from about 100 countries come and participate. So in the Jessup Moot, it's usually on, the dispute is going to be, subject matter is going to be on international law, where the students would be taking a contention, where they will have to be appearing before ICJ, or it could be where considering how we have a lot of international issues at the moment. It could be the issue in Gaza, where International Criminal Court also is included in such moods. So similarly, you know, uh, so here generally, whenever you can check online, just Google. I think two of the moods have already taken place for this year. You can look at the links. So it's held globally. So it's in Geneva, Washington, and in the international forums. So your prelims could happen online, or they will look at you know how well you speak. So please keep in mind that all of you should get to this level of representing in these moot court competitions, or anything. So now, if you ask, the next question is, how different is mooting from a debate? So one moot is generally about you discussing the law. Debate could be on an opinion. So while I say it's about law, that means you are connecting the facts with the issues and produce evidence. So while in case of a moot, what happens? You are going to exchange opinions. So it is there is no legality as such when you are trying to look at the foundation of a debate. So why do I say this? It doesn't necessarily have to be where you are a good debater. As long as you have the zeal to be taking part in a moot where you are backing your advocacy with research, and how well you argue, or how well you take in or analyze the legal issues, becomes the crux of, or the foundation of a moot. So unlike in a debate where you're just rebutting, or there is exchange of talks between the two parties, moot involves much more, because there is an in-depth analysis of what you bring in, how well you back your arguments for the issues raised, and what is that you seek. So always remember, merely because someone speaks well does not mean only they are eligible to moot. So it is based on your zeal, and always give it a shot. One starts with your research, and after which you will start discussing, or rather channel your arguments. So, like I already said, the benefits of mooting is you learn to research. It's not just for taking part in competitions. You learn the art of legal research and how well you write memorials. Here, at this point of time, you might just think it is for a moot court competition, but in general, you learn the art of writing. If it has to be concise, how well you articulate a particular issue and how do you put forth a point. And then you also learn how to communicate. When you say communication, how well you convince the judges regarding what you're trying to purport for your client. So this in turn enhances your critical thinking, or how well you analyze a particular fact in case or issue in hand. And then, and effectively, because it's a moot, not a real court, you are, you have a time limitation. That is where you have to, your drafting and your oratory skills come into picture. How clearly or how precisely you put in your point, and how can you argue even if you have a limited period of time. So, like I said, practice makes a man perfect. So we all know this. Similarly, like how you develop certain skills, it could be swimming. Uh, unless you delve into the art of advocacy, unless you start, you know, taking part in a moot court competition, you really don't learn the art. So that means you need to uh, first sign up, and then you need to start looking at a problem, and then start refining your skills. It could be your research skills, it could be your presentation skills, or it could be your writing skills. All of these are developed only when you plunge into it. You cannot merely say that I will do it when you pass and then you appear before a real court. So this is about how you need to start from now, so that you learn the art of advocacy. So coming or delving into understanding what could be the requisites of mooting. So one, whenever you're given, usually a problem is released, and in most likely circumstances, you have also been given the issues. First, you will have to understand the problem. Try to look at three aspects. One, what are the facts? Once you know or understand the facts. So facts is not just reading once or twice. You have to keep, reading the problem multiple number of times, and try to phrase your thoughts in two aspects. One from the petitioner side and another from the respondent side. Then try to understand the maintainability aspect of it, and like whether or not the legal jurisdiction that you want to argue before is applicable. And thereafter, you will have to identify the core issues in the problem. So this is your first step of when the moot problem is released. You will have to understand the problem on three aspects: jurisdiction, facts, and the issues. After this is where you plunge into the research. So that is when you will start looking up. You begin with finding what is the treaty, or what is the law in hand, and identify every applicable law and the rules that is relevant to the problem. Thereafter, you start looking up for the case laws. What is the relevant legal precedent? Do you have it within, for instance, if it's a national moot, you look up before the High Court, Supreme Courts, or any lower courts, and thereafter see the relevancy of it. Identify what is relevant and focus on that to purport for your drafting or for your argument. So this is where it becomes your legal research and case preparation takes a lot of time, and you should ensure you do a thorough research or look at multiple sources when you are coming to the third stage of drafting. So your drafting is determining or is going to be only good only when it is backed by good analysis and legal research. So now I am going to further discuss on what is what. So when you're reading, once the problem is released, you try and read. So how do you know? First is whenever the facts are given, they lie the foundation or they become your uh, preliminary understanding of what could be the issues. So based on this is where you determine what is the applicable law and what are the applicable or relevant case laws that you could refer. Generally, whenever it is a moot, you cannot alter the problem that is given. That means problems or the facts have already been stated and you can only infer from what is being given to you. You cannot contradict. Why? Because when you are appearing before a panel of judges in a moot court, it is in sometimes they might ask you where is it said or what is where are you inferring this from. So always ensure you stick to what the problem is and how relevant you take from there. So law is or your moot is going to be shaped by what is detailed in the moot court problem. So that is when it becomes essential. Whenever there is a moot problem, there could be situations or there could be circumstances where there are relevant facts in it and there are irrelevant facts just to confuse you. So here is where you have to identify what could be legally relevant and what could be irrelevant. And after that, you prioritize based on the relevant ones and the irrelevant ones. After which you have to see, when I say relevant, you will have to understand what could be admissible and what could be taken further for your legal analysis and research. So only then will your arguments further strengthen, and you can argue better, or you can seek your prayer, or it is going to be a win-win situation for you. So the most important factor is time management. So similarly, when we say things are given, it's time bound. In a moot court in a scenario, you don't have much time. Let's presume you have 20 minutes and you have two speakers. That means whenever you are looking at narrating the facts, usually in your preliminary rounds is where you will have to narrate the facts. You don't have to assert everything. The problem is given. So if you will have to quickly summarize in about 2 or 3 minutes, give a summary of what the facts are. So that means you have to be very concise and you don't waste too much time on summarizing these facts. So ensure you are giving it in a crisp and a clear way, and don't waste time on facts which can detract or which becomes irrelevant to your arguments. Then you start with your opening statement where you seek the permission of the panel, and then what becomes very crucial is how you begin. So your preliminary statement. So when I say preliminary statement, so the first 3 minutes is where is going to be crucial for you. That means you will have to rehearse, you will have to practice, have mock trials so that you can capture the attention of the panel of judges and set the tone as to what you would be arguing further. That means usually whenever there are two speakers, it's the first speaker who will present the facts in a moot court, and thereafter the second participant or the speaker is only going to be taking those facts or those segments of facts which is going to be relevant for arguing the issues that they would be speaking. So facts cannot be repeated by both the speakers. So it's the first speaker who will summarize the facts or set the tone, and the second speaker would only be addressing the issues or the essentials that is required for their arguments. Now, when moving on to what? Now you've opened the statement and later you will have to start with your issues. Now, how do you identify issues? So one, like I said, you will have to look at it or read the problem from both aspects. That is your petitioner and the respondent, or an appellant and a respondent. So here, when you are saying you have to read, try to identify the issues which is relevant or which has legal backing. So once you know what legal backing you have, once you have done a thorough research, then you can start backing that with case law, and your arguments will flow naturally if you have your thorough research done on that. Now, next comes, how do you define what an issue is? So when you say mooting, usually the crux of mooting starts with an issue, because unless you have an issue, you don't come and ask for a relief. So that is why it becomes very, very important. So there could be certain moot court competitions which will already give you issues, or there could be certain competitions which don't give you the legal issues and the problem. So that is where you have to try and interpret, or what is an issue. The Civil Procedure Code tries to say issue is a contention where it is affirmed by one side and denied by the other. If I have to put it in other words, issue is a point in question where it is a subject matter of discussion or a subject matter of an argument, and you, because of having an issue or because you are trying to say that this is wrong, that gives you a right to relief. So this is how important or how well you have to structure your issues. Again, when you're coming to issues could be factual or it could be legal. So when I say factual or legal, first you have to infer or clearly read the problem, saying what could be the relevant factual inferences or factual issues that you're trying to have. So try to minimize your factual issues, and then limit your arguments on the factual issues, because there is no contention or there is no dispute when you're raising these factual issues. So that is when you will have to focus more on the legal issues, because you have to show your research skills and your oratory skills. So, like I said, sometimes, usually, in a real court setting, you will have to frame your issues. In moot court problems, there are both the circumstances where certain problems are pre-listed, or it could be where you will have to make issues based on the problem. So based on that, don't try to over-analyze or overstate the facts. Look at it from analyzing from a legal perspective. So this is how you try and ensure you are making your point in the time limit that you have got. So in many instances, or rather the reality is, you might be wasting too much time on the factual issues or on the facts where you do not have sufficient time to argue. So make sure you time yourself, practice, and ensure that you are not wasting too much time on asserting the facts. Next comes, in the issue, trying to ascertain the burden of proof. What do we mean by burden of proof? So once you frame issues, you will have to prove. So what is the proof? That means whoever is proving a fact, and it never shifts. So when I'm saying, there are two aspects. One is burden of proof, and another one could be onus of proof. So burden of proof is lying on the party that you're on the client that you are seeking justice for. So that means you are going to be asking, you have to prove the fact, and it is never going to be shifting to the the defendant or the respondent lawyer. While the onus of proof in many circumstances, it could be on the other, the opponent lawyer, where they will have to prove the case against your client. So this is about trying to understand how, after you frame the issue, you will have to identify what are you trying to prove, and the evidence you have always have to back these whatever issues that you raise by what you submit to the court of law as proof. So that is when you will have to look at the legal procedures. So based on what the subject matter is in hand, you will have to look at what is how do you present it, and what is the proceedings of the court, what is the procedure, and how the judicial officer takes it. So this most likely circumstances, it could be where it will come before it will be set forth in the moot problem itself. So now when I'm saying someone asked me about onus of proof. So onus of proof is going to be where it's an obligation to prove a particular case against, let's presume you are a defending lawyer, or it could be the opponent lawyer. So it could be either ways. Onus of proof can shift to depending on the facts of a particular case, whether you want to say, let's presume a particular individual is not an accused, or you want to frame him to be an accused. So that is what is onus of proof. Burden of proof becomes you are trying to defend the facts that you have with evidence. Now next question comes about how much a particular speaker has to be speaking. So that means, since when you're looking at a moot court problem, it is based on how much an individual participant scores. So always ensure both the participants have substantial issues to argue. That means both of them have a fair chance of getting higher marks. Now let's presume there are 5 issues. So try to allocate or try to ensure your research is backed for all of these issues, or both the speakers are strongly arguing. It could be for both the sides, or whatever be the scenario. Ensure that both of you score better, and try to balance your arguments, and ensure that both of you are making significant contribution as speakers. So this is very, very important, because and one speaker could be scoring higher over the other. So ensure that you balance while you're discussing the issues also, that both of you have strong arguments. Now comes the importance of research. So while I say this is, if issues are setting the tone for a moot, research is going to be the backbone for your advocacy. That means always ensure that you have the whenever you're speaking, you can't make factual arguments. That becomes a debate. So in moot, all you have to do is back up everything with every legal precedent, or even if it has persuasive value, try and put them in your analysis, or put them in your memorial, and back everything with case studies. So these become the most, or this is your crux of research. So when I'm saying your primary sources will become your precedents. So it could be which is binding on the jurisdiction that you are arguing before, or it could have a persuasive value, and you will look up if it is going to be an international dispute. So you will look at what are the relevant international laws, case laws, what could be the regulation, and what would be the statute. After that is where you will look up other sources. It could be your textbooks, it could be your journals, or legal commentaries. So all of these become very, very crucial for you, or ensure all of this is there whenever you are, arguing. And all this has to be produced when it is when you have something like, let's say, path breaking for your case law. Ensure that you produce before the panel of judges. So that means if you're merely speaking and you don't have anything to back it up with your legal analysis, then your argument is going to be very diluted. So just a quick ice breaking slide where you cannot say, uh, you know, something like this. Now comes the next aspect, where or how you will make a memorial. So when you're creating or making a memorial or drafting a memorial, you'll have to ensure what the usual things. So it could be starting with your table of content, and it could be your abbreviations table of cases, and then I will your stating the facts. So what you would put forth as statement of facts. So here you will have to present facts. So whenever you're presenting the facts, ensure you format it right, you phrase it right. So don't clutter the memorial with unnecessary or excessive facts. Keep it simple, keep it crisp, put them in paragraphs. And also, whenever you're making something, like I already said, how your research should be backed by case laws or whatever is the relevant secondary sources as well, you should keep a copy of that and produce it before the panel of judges. So whenever I say, because even the judges in a moot court scenario will have limited time, so try to ensure there is clarity in how you draft. So they will look at what are the things that you are trying to assert in, use a simple plain language, and make sure you put them, or you create, you brief them up correctly. Now I'm just giving you how do you streamline your content. So when I'm saying streamlining content, how are you going to understand how much facts should I have, or how do I edit it? So now whenever you have statement of facts, it should be a concise version and not what the problem is already giving. So one, you focus on the relevant facts that we earlier discussed on. For instance, a summary of facts cannot be exceeding more than 2 pages. Let's presume if it's a 10-page memorial. So this is your limit for how much your statement of facts should be. So after asserting the statement of facts and stating the jurisdiction, you will have to include your issues. So in your issues could be your preliminary or objections. Then you discuss on the factual issues and also the legal issues. So this is how you structure your memorial. Now next is going to be how are you arguing. So you usually you would see a summary of arguments apart from arguments advanced in a memorial. So in certain cases, summary of arguments is optional. In another or in certain instances, summary of arguments give a clarity even for your argument when you have a time restriction to it helps you stay focused on your arguments and not deviate too much. So always ensure whenever you are submitting, make a summary of arguments so that it will help you stay focused when you are arguing. When when you are making the summary of arguments in your mock trial or in your mock preparation, ensure try and say what are the relevant facts that you would be using and how will you cite it when you're arguing. So if you do not have a clarity of understanding how and when for a particular issue, how you will argue by backing with all of this, that is when you will lose your marks when it comes to scoring. This is, I am talking from a winning perspective in a moot court competition. Now, like I said, so here let's presume you have 4 to 5 issues. So that is where you have to try and link or try to say how the issues are, how the facts are, the relevant facts are clearly, you know, raised as issues. So that means in every issue that you are trying to, raise as questions or put forth, you will have to state what is that is, not right. Apart from the prayer, you will also try to include in whenever you're raising each issue, what would come in the prayer as your desired outcome. What are you trying to seek from court, and what is that you want to undo? So this clarity on every issue, if you can have, that will clearly tell the or that will clearly help your client also, or in in your competition, that you have a clarity of what you are seeking from the court or from the panel of judges. So next is about prayer. So whenever you are seeking, or whenever you're trying to ask uh, the court, what you have to do is, first is, the etiquette is where you stand up when the prayer is said. Apart from that, you have to be very very clear, or you have to uh, you know you have to ensure what you are seeking from the court and what you want the decision of the court to be is purported or supported or backed by all the supporting material when you are making this prayer. So if there are any relief that you are seeking, you have to justify, why or how much, or the rationale behind the local cost. So it should be a legal basis. You cannot merely make a statement without a rational analysis of what it could be. So after preparing your memorial or drafting your memorial is where you have to prepare for your oral arguments. So when we say oral arguments, your oral arguments will only be good if you've well drafted your memorial. So that means you need to ensure every argument or everything that you present before the court or the panel of judges is in your memorial. So first, familiarize, keep reading. Once you draft your memorial, ensure that you read it time and again, because whenever you are arguing, or whenever you're before the panel of judges, they will look at your memorial and then they will ask you questions. So this is where they might just ask you, you have written in your memorial, but if it is contrary to what you are speaking, then again you might lose marks for that. So include and argue what you have drafted in your memorial and assert that backed by your legal research. Since, like, whenever we say moot, you most likely have time limits. So since you have time limits, it is, you don't have much time. So it could be speaker one gets a lot of time and speaker two might lose time. So for that reason alone, be very, very clear. And whenever you're presenting your arguments, ensure, that is where I said your summary of arguments come into picture, where you know what you're speaking and what you get, and every minute matters when you are arguing, or when you're persuasive in your reasoning. So be clear, be crisp, and be concise. So that is when it is important, even when you're arguing, or when you've gone for your oral rounds, include or make pointers of how you structure your arguments, how do you tackle each issue, and how are you backing that logically and legally. So when I say logically and legally, keep everything in handy. Now let's presume you're relying on a particular uh, article in a journal. So for which, ensure, now let's the judge might ask you, can I see it? So you will have to have a copy of those, you know uh, those scholarly articles or those secondary sources as well, which becomes very relevant for you to make your point. So now when I'm saying all of this, usually we know a judge never is someone who will just listen to you. So that means whenever you're arguing, a judge will also ask you questions. So for these, you will have to be well prepared, and you need to have certain answers. So how are you going to tackle these answers? So whenever you're saying, whenever you have to answer, your answering should be reasonable, and it should be again logical. So that is why you have to prepare well reasoned answers whenever someone poses, or the judge poses a question before you. So here is a quick tidbit of what it is. So while you begin, now you just seek permission. Then once you seek permission, just wait for the judge to acknowledge. Now, if in circumstances where the moot is held virtually, this is one step that you could avoid in your oral round. So you don't really seek permission, that is to approach. You will uh, state that if you could begin with your contentions and start. So this, I know you are going to be discussing further, but the foundation lies in all of these also, where whenever you are addressing judges, you have to address them very, very respectfully. So depending as if it's a male judge, you will address them as your lordship, and if it is a female, it could be ladyship. So always remember, whenever you are arguing, you should be, you should make your representation uh, or rather, your talking should be formal, and it should be clear, and it should be crisp. You cannot use indirect speech. You cannot talk informally in a courtroom setting. So that means that further takes us to how well you appear before the judges. One, you need to be confident. So make eye contact with the judges. Don't uh, unnecessarily use gestures, which is in contradiction to what you are there for. So stand straight, upright, and then project yourself confidently. Whatever arguments you are making, speak confidently, and there is no hurry, because we have a time management. Then it could be where you're not speaking too fast. Speaking too fast means it could be where the judge will presume you have not understood, or you have no clarity in what you are arguing for. So just try and speak slowly, clearly, and ensure, even if you are under a pressure, you know what you're speaking. So this comes only with practice. Even before you're appearing for a moot, that is, try and rehearse as many times as possible. So someone asks, what is approaching the dais means? Approaching the dais is, now let's presume you are in a moot court competition. So once the judge comes, you will have to seek permission whether you can start your arguments. That is whether you can uh, begin, summarizing or stating the facts, then, going forth with your oral submissions. So, how do you structure, or what will your, memorial have, or what will you speak? So here, your oral arguments will usually have an introduction. That means, uh, uh, usually at in your preliminary rounds, it could be where you will say what, who, whom are you appearing for, and you will state the jurisdiction, and after that you will brief or give a summary of what is the relevant facts, and then start to raise the issues. So once you state these are the issues, you will argue your issues, which is based on what you have given in your memorial, purporting the relevant case laws and, you know precedents. So later is where you will seek the specific relief. So you will say what are you trying to ask the court, and what you want the decision of the court to be. So this is how you structure even your oral uh, oral presentation. So this is one scenario where, now let's presume you are at the interrogation level. So can you just say, where if you do not back by legal reasoning, you cannot. It has no substance. It dilutes the very purpose of arguing, or the very purpose of what you're trying to seek, when you do not have a substance as to what is wrong and why is it wrong. So try and answer the what and the why of a particular issue. So why do I say grilling? So this is where a lot of people, or a lot of you, could be scared. What will the judge ask? So when you are speaking, in most likely circumstances, it is just it could be where the judges may stop you and try to look at understanding, or try to analyze how much have you understood, how, what is that you are trying to speak. Now let's presume there is something that the judge wants to ask from your memorial. He could point out that as a flaw, or he could ask, what are you meaning by something in your memorial, as a clarification. So what do you do when, it's a two-way street. If you are presenting something, one, you should not be scared if the judges are going to grill you. Just try to stay calm. Try not to be under any pressure. Now, if you want to, once the judge asks a question, take a moment. Try to get a clarity of thoughts, and then answer. If, let's presume you do not know what the judge has asked you, and you do not have a answer, so you can humbly tell the panel of judges that you do not know. Admit it gracefully, and say that you will deal with the other aspects of the particular case, or where you have stronger arguments. Go to those relevant issues and advance your arguments for that. Now, when it could be certain instances, or most likely where it cannot go exactly as you rehearsed. That means you might have to adapt to what the judge asks, and immediately here is where you have to be quick. So it could be whatever would be the relevant issues and facts you have uh, stated before the panel of judges. You will have to prepare your response. So that means you will have to be uh, you know very you have to be flexible, and you will have to back whatever you have in hand, whatever is your legal research. you could take something and answer with the help of that particular research that you have in hand. So don't try to always have a very fixed approach. If you know a particular thing and you can purport or back that when a judge asks you, feel free, be very flexible if it is trying to help you in your arguments or in when you're interrogated. So next is where, whenever you're trying to understand, how important each of you play. It is a teamwork. That means both the speakers have to know what they are going to be addressing, how are they going to be arguing, and ensure it's not repetitive. So why is this important? Because whenever you're researching, it could be where you have time constraints. Ensure each of you divide, how on what issue you would be researching, and then once you are arguing, make sure that there is a seamless transition. What do I mean by that? It should be connecting. There should be a link. It should not seem like two different cases. So it should be a smooth handover between from speaker one to speaker two. So this is where your team efforts will be shown, or rather, you will understand if each of you divide and conquer, there would be a greater chance for quality research and also scoring better in your competition. So this is about all about how well or what you have to be doing. So here I am saying about mock trials and feedback. So why do I say mock trials or mock moots? Even before you're appearing before a moot court competition, try and rehearse. Okay, so one, as a team, you practice amongst yourself, then go before your cohorts or peers, then make a presentation before them, and then go before your faculty and try to give or make a mock moot. So that is where you will try and understand where you're going wrong or how you're going wrong, and seek feedback. So however, whatever feedback is going to be a constructive feedback, because this will help you appear or present before whenever you are going for a competition. So whenever you're doing all of these, time yourself. So when you time yourself, you know where you should cut down on your time, or where your argument is not strong, and how if you're not confident, if there is certain in a certain way that you have to enhance your oratory skills. This is where you will, when you time it, is where you will try to do better. All right. So apart from that, if you are, or rather, it would be my personal tips as to how you would succeed. One, whenever there is a moot court competition, start early. So see whether or not you are able to, you know, uh, take this up. So your preparation is everything, and how well you research. So whenever it is, you should ensure that you have enough time to research. Once you research, it's also that you have to give equal time to drafting your memorial. And since you have to be doing for both sides, ensure that you have enough time to look up for both, that is on the both sides. And whenever you are arguing, don't sound very artificial, be natural. This is your personality per se, where you have to be confidently talking, like humanize. You're not like, because we are in the world of AI and things, or you don't have to sound like a robot. So you will have to ensure that be confident and be speaks naturally. And whenever there are interrogations or any grilling that happens, stay calm. And thereafter, the when judges ask you, it's not for anything else. It's just to challenge how well you have understood a certain issue. It's not to, personally target you or things like this. So while you're arguing, it could be where, the first speaker might not know how to be doing, a certain issue. So try to keep it precise and try to make it, you know, where your strong arguments are, try to focus on those strongest issues and, rehearse in such a way that you have sufficient time to for both the speakers to handle all the issues and conclude with a prayer. So there could be many instances where you would have not finished all your issues, even though you have your arguments, because you have time constraint. The judge might just say, conclude, what are you seeking from the court? So that is precisely why you need to time how you are arguing for each of the issues along with, seeking relief. So these are the key points which you have to remember whenever you take up a particular mood. So that's it. So I think uh, it's not just about whether or not you want to looking it from a winning perspective. So I strongly encourage all of you to take part in moots, because you learn the art of research, learn the art of advocacy, and also how to critically analyze, how to draft. So this is going to be the most valuable experience that you would have as a law student. That is the one which bridges the gap between what you learn as, let's say, sections and rules to what you would require as a, a real a skill as when you come out, when you are enrolling for a bar. So please practice, prepare. I encourage everyone here to take part in moots and excel well. For those of you who have not started mooting, uh, give it a start. So this is your beginning. Try and make sure you make the most from all the sessions that is there. So that's it from me. Thank you, and good luck with your mooting journey.
Thank you, ma'am, for generously imparting your wisdom and enriching us with your valuable experience. It was a pleasure listening to you. Thank you so much, ma'am. Now, I would like to invite Ms. Purnima Gautam, ma'am, member of organizing committee and assistant professor KSLW, to deliver a vote of thanks.
Thank you, Niharika. Greetings to all. It's an honor to have been asked to propose a vote of thanks for such a wonderful session on fundamentals of mooting. Moot court competitions definitely help the students to learn the art of articulating the legal skills, which is essential for law practice and will eventually expose and acquaint them to the challenges of adjudication. Now, first of all, I, on behalf of Kanoria School of Law for Women, would like to extend my heartfelt gratitude to our esteemed guest speaker, Ms. Ramya Prakash ma'am, who spared time from her busy schedule and gave a vivid outlook on the advantages and benefit of mooting. She stressed on the importance of mooting in a lawyer's journey and the difference between real courtroom and moot courtroom, and various benefits of mooting like better research, drafting, and oratory skills. Ma'am also enlightened students about the various most prestigious moot court competitions and the steps for mastering the art of mooting. Thank you, ma'am, for giving deep insights into the topic and for patiently answering all the queries. Next in line, I would like to extend my sincere thanks to our respected principal, ma'am, for encouraging us to do our best and standing as pillar of strength, and for extending immense support in organizing this event. I'm immensely thankful to the people who have been the backbone of this event, Ms. Disha Bangarwa, co-convener, Ms. Roshan Ali ma'am, organizing secretary, for organizing this session. I also extend my profound thanks to all the staff members for their enormous cooperation. Next in line, I would like to thank all the participants for joining for the session. I'm hopeful that this session will enhance your skills to become a good mooter. I also extend my hearty vote of thanks to the moderator, Ms. Niharika, for moderating the session so well. Once again, I thank you all for your cordial cooperation. Thank you, everyone.
Thank you, ma'am. Announcement for all the participants that in order to receive a workshop participation certificate, all the participants must fill out the feedback form which is provided in the chat box. Now request all the participants to switch their cameras on to capture this movement.
Excuse me, निहारिका.
Yes, ma'am.
ये पीपीटी बस वही पूछ रही थी. पीपीटी किसके अकाउंट से खुली हुई थी? Fine. Now everybody is visible.